And Eric, do you want to try speaking as well? So it's all good then.
Hello, Patrick. Can you hear me?
Yes, very well.
Okay, fantastic.
Okay, good luck, everyone.
Thanks, Felipe. Can we also check if the interpretation is working fine? I see some comments in the chat. Okay, I do hear Spanish in the channel. We'll start in 1 minute. It seems to be okay. Yes, we can hear you. Okay, I think we should start in time then. I would request the UNESCO team to start recording the session. And I think we have enough people joined for the session now. So, well, hello everyone, and welcome to the Open for Good Alliance webinar on Open AI and data in law and justice systems. I'm Prateek Sibal. I'm a program specialist at UNESCO's Communication and Information Sector, and I will be your host today. It's also wonderful to engage with the community of judicial operators from 140 countries who joined us for the global MOOC on AI and the rule of law earlier this year. And I see some of the participants of the MOOC have also joined us now. So hi to everyone. And we must also thank you for the support and vote of confidence in UNESCO's work on AI and the rule of law as part of its Global Judges Initiative. Before we begin, I would like to thank my incredible colleagues, Vanessa, Charlene, Jason in Paris, Cecilia, Eduardo, and Soledad from Montevideo, who have helped put this session together, along with our partners from GIZ. Thank you, Jonas. So one of the major challenges to developing localized AI solutions is the lack of inclusive, localized training data of sufficient quality. And the Open for Good Alliance was born to support the development, discovery, and storage of such data through different channels. The Alliance attempts to make datasets openly available. It facilitates coordination and exchange of good practices and ideas, as we'll see today, between Kenya, India, and Brazil. It aims to increase public awareness for the benefits of openly available, unbiased, localized datasets. Today, the Alliance has 15 members. And the focus of this session is on the justice systems. So AI systems are being used in justice sector to make administration of justice more efficient through algorithms that can help in legal research and document analysis, to algorithms that are being used for predictive justice systems, from setting or denying bail to sentencing or assessing likelihood of reoffending. With, of course, to underline, there are associated risks to human rights. However, as much as human decision-making is susceptible to bias, the objectiveness of AI-driven systems also depends heavily on the underlying training data sets, compiled and curated by AI practitioners. To unpack this data aspect is the objective of today's discussion. Through the presentations of our three speakers from Brazil, India, and Kenya, we'll try to address the following questions. First, how is AI used in law and justice systems across the three countries? And what are the institutional and societal factors that contribute to its adoption? Second, what kind of governance mechanisms and cooperation between technology and legal communities are driving the movement towards open AI and data in law and justice systems? The third question that we'll explore is the barriers in the development and deployment of AI and data tools in the judicial context. And what safeguards do we need to put in place for ethical use of AI in justice systems? And finally, it's quite a packed agenda. We will try to uncover what are the aspects which are key to making open AI and data initiatives in the law and justice sector scalable and interoperable. And that's why we're kind of facilitating a global South conversation to learn from good practices from each region, but also to provide the participants today, a lot of whom joined us for the global MOOC on AI and the rule of law, some tangible solutions that are being used. We will have short presentations of 12 minutes each by our speakers, and then we will open the floor for Q&A for about 20 minutes. So without further ado, I would invite Rafael Leite, who is the assistant judge in Brazil and has been working very actively on the Justice 4.0 initiative in Brazil. Rafael, the floor is yours. Thank you.
Thank you all for the invitation. I'll try to use my time as best as I can. I try to cram up as most of the initiatives that we have to present in this lecture. And let me try to share my screen. So here in Brazil, we are currently developing the Justice 4.0 program. It's the main initiative in digital transformation of the Brazilian justice system. It's a program that's it's an initiative from the National Council of Justice with support from the Federal Justice Council and with the participation of the United Nations Program for Development. The name Justice 4.0 is a reference to the Industrial Revolution, and it's current called the fourth revolution, focused on autonomous decision making. It's a cyber over physical development of the production systems in industry and service, systems guided by data and focused on using machine learning, intelligence, and cloud technology. But to present that, it's interesting to show the context in which it's developed. So Brazil is the 5th largest country in the world. It's the 7th most populous country. It has more cell phones than people, indicating a good level of at least basic digital literacy by the population. We have 424 million digital devices. And another interesting aspect to understand why a Justice 4.0 program in this country, we have over 1,500 law schools and more than 1.2 million lawyers. It's probably, I think, more than the rest of the world combined. And the judicial branch to work with that is around more than 400,000 people and around 18,000 judges distributed in 91 courts with currently 75.4 million active lawsuits, of which 96% are electronic. And at this, we're achieving in this year 100% filings of digital lawsuits and aiming to have 100% lawsuits in the following years. And all of that objective has already been reached by more than half of the courts. So 48 of them already have 100% electronic lawsuits. So it's in that context that we get the Justice 4.0 program. It's designed to take the public service given by the judicial branch to the next level and the expectations of society in this new context. And it could be summed up as the idea of bringing justice for all with innovation and effectiveness in mind. As I said, it's a program from the National Council of Justice. It aims to promote access to justice through the development of collaborative actions and projects that use new technologies and artificial intelligence. So quite aligned with this webinar. We could sum up them in four main branches of activities that are being explored by the Justice 4.0 program. So the first one that we can call it's the 100% digital court that aims to transform courts and lawsuits in a digital way. So the perspective is that from filing it to the final decision, it goes only through digital systems and through digital interaction using messaging and digital conferences, and no presence of the parties in a specific building. We also can refer in line with that. It's the Courts Virtual Service Center. And the idea is that all over-the-counter services given by courts can be accessed through messaging services or online or the internet. And you can talk to the public servants or to the judge himself through any messaging services or video chat program available online and get the usual services over the internet. Another really important branch and I think the backbone of what we're discussing here today is it's DataJud. It's not enough to have all the lawsuits in a digital form, but actually getting the data to create reports and get a good analysis of how things are going in the judiciary. And the final part, and I think the more technological advance and the hub for innovation is the digital platform of the judiciary, which we will explore in a little more depth in the following minutes. So the 100% digital courts, it's distributed and being used by many courts all over the country. And if you look for a map, we have an adoption in all states with different level of adoptions. Despite the difference in human development, the level of accessibility to internet, we do have a good distribution of it, and we have reports that of it really helping people to get better access to justice. With the Courts Virtual Service Center, we also have broad adoption using applications like Google Meet, Zoom, WhatsApp, and Teams. With no need of prior scheduling the meeting or the service. You can get quick and ready access to the usual over-the-counter services through the internet or through your smartphone. Talking about the DataJud initiative, it encompasses all the information regarding the lawsuits that we have currently as a caseload in Brazil, but also past cases. So currently, as I said, we have around 75 million, but on DataJud, we have around 400 million lawsuits from the past and that are currently not making part of the caseload, but are relevant for statistical analysis and the creation of reports that we use now as a fundamental part of decision-making in the judiciary. So with this data, you can get on-the-fly information. It's currently being sent by each court to the National Council and created through using BIs and data analysis strategies. But we are aiming to build we're building currently the infrastructure to get that on the fly as soon as the lawsuits are filed and following in real time all the way to the end and the final decision. So we have a current system that it uses traditional methods of extracting the data from each court, but we are in the moment creating the infrastructure to get that information, as I said, as soon as it's available. It also helps with finding inconsistencies in each lawsuit. So even though we have 91 courts, we get the same information with the same parameters through a process of data analysis and trying to make all the information consistent despite regional differences. We have some norms from the National Council that establish the values and the ID. So despite if the lawsuit is running in a northern port or some port from the south, the east or the west, it doesn't matter from which region. Every one of those lawsuits will follow the same set of information, and we get a good grasp of how they are behaving all over the country. So now I'll focus on this building of this infrastructure to get that information to be readily available. And the main hub for that and the hub for innovation is the national platform, the digital platform of the judiciary. And that platform came as a solution for a specific characteristic of the Brazilian judiciary. It's not exclusive to it, but we have different systems serving this 91 courts, and they have specific data structures and use different codes. But we did try to converge to a single system, and even through extensive measures, we didn't achieve the single system to serve all the judiciary. So instead of focusing on forcing courts to adopt just one specific law system or data structure or database, we are creating the means by which each and every one of them can talk to each other, and we can extract actively and provide services and new applications to them. So they are connected through this hub, the platform that provides services, data to each of the courts. And there's a quick presentation available in English in this National Council of Justice YouTube channel. I invite you to follow it there, but since we have limited time, I'll let you guys try to explore. I'm leaving the QR code for the video here if you feel like accessing it and know a bit more of what we're doing in this part of this change in open access to justice and getting systems to talk to each other. The idea is that it works intertwined with the systems. So for most users, they won't perceive that you're actively getting into a new platform. The idea is that it's providing service on the background, but we do get some systems that you're going to be able to access from it. So if you're accessing a specific eCourt system, so one of those that I presented to you, you might go to a different system and get a specific information that you need, or even a different presentation of how your caseload is behaving, how your court is processing the caseload that it has, or if you need to get information for a specific branch of the public service, or get access regarding criminal information of a specific party, you can get that through the system, and it will be able to encompass all the systems and all the data from the lawsuits in the country. We currently have many projects coming and converging to this system, and the main and basic idea with this platform is that any new development by courts, it becomes an immediate solution for any other court. So any new project that it is developed for any of the 91 courts will be able to be used by other courts. And I brought 4 examples for you guys of projects that are here. So the Sniper project is one that is capable of assessing information regarding parties in a lawsuit if you need to see their interactions or relations with different systems, assets. You can see that and use it to find the specific measure or line of investigation to reach the desired outcome of a specific lawsuit. The JUMP projects, I think I'll be showing you ahead. It makes it able for you to see the flow of lawsuits in a specific court, and it tries to generalize it. So it's kind of an automatic overview of the flow of lawsuits and which part of the processing of those lawsuits is taking more time. And we have two other platforms that is in this national platform, this digital platform. It's the Synapsis platform and the Codex platform. One is aimed at AI and the other one is aimed at big data and data extraction from every court. So with the Synapsis platform, we have most of the national AI projects hosted in a single cloud system that makes them available. So we don't have only a platform for AI. It hosts and it's able to manage all these projects that are available. We currently are making an annual research regarding this project, and we have 53 courts with AI projects. There are over 88 projects in this courts, and most of them are in production. So we have them also all over the different branches of the judiciary. So we have them in federal courts and state courts and even superior courts with their projects. And many courts have multiple systems, and we also in the National Council are in relations with academia. So we have 3 different teams from 3 different universities from Brazil. We also have the team from the State Court of Rondônia that's responsible for the national system. So they created a platform and they have over 20 AI projects already available to be used. And we also have a specific team from UNDP. Just to cite some, we have
Rafael,
AI. Oh, hi.
Rafael, I will have to do the unthankful job of being the moderator here. So thanks for the presentation so far. I think we can look at some of the detailed aspects if you'd like to share the links in the chat as well, and also during the Q&A when some of the questions come up. But if you want to say some concluding words, please, 30 seconds, and then we move on to the next presentation.
Okay, just so as the main focus is the extraction of lawsuits, we already, at this moment, we are creating the underlying structure that's extracting data from all those 75 lawsuits. And our expectation is to reach around 100% of those courts integrated till the end of the year. We currently have 21 million lawsuits in this underlying system with information from all the courts. And that should be the main focus. One of the challenges of making that data available in most of the time is having it available for the guardian of the data. And we are trying to solve that problem to, from that, build a more open and more accessible information for all, not just the judiciary. Sorry for taking more time than was available. Thank you, Patrick, and that's it.
Thank you, Rafael. I think it was great to hear some of the institutional aspects also, and the big push which comes from the judiciary itself in Brazil towards digital transformation. And this really brings us to the next speaker, Supriya Sankaran, who's co-founder of Agami and has been working with the innovation community to make the bridge between the judicial community, the lawyers and the judges, and the innovation community in India. Also a big judicial system. So Supriya, the floor is yours. over to you.
Thank you, Pratik, and thank you, Raphael, for really inspiring us all with hope about what could potentially happen in our respective countries. It's really my privilege here to share a bit of, and give each of you a bit of a glimpse into what is happening in India. Interestingly, some of the main changes that have been happening here, in contrast to what we just heard from Brazil, has been less, fundamentally, there has been digitizations with the code, but work around AI and data, there's a lot more to be done there. And most of what I will be sharing with you is what is happening in and around that ecosystem. The first part I would like to show you and literally give you a glimpse of some of that. So I'm going to be sharing my screen. What you can, if you all can see, that has been a collaboration between the government and the private sector to address a core problem in a country like India, which is we have 22 official languages and many, many more others, in terms of how do we use AI and data to solve the translation problem and enable text-to-text conversion in different languages and voice-to-voice and voice-to-text, right? I'm going to be showing you a quick demo of how this works in the current context.
So I think we don't hear the audio.
Here. Do you hear it now? You can check your recording. You have to come to the Bhashan. Do you hear the recording now, Pratik?
Yes, yes.
Sorry, I'll just start it again. You have to come to the Bhashani website. Select your source language. I'm choosing English here, and your target language. I'm choosing Hindi here. And then make your recording. I am a migrant worker working at a construction site, and my employer has not paid me my dues for the past year. You can check your recording. I am a migrant worker working at a construction site, and my employer has not paid me my dues for the past year. And then you convert it. Takes a few seconds. And here we have it.
मैं एक निर्माण स्थल पर काम करने वाला प्रवासी श्रमिक हूं और मेरे नियोक्ता ने पिछले 1 साल से मुझे मेरे विचारों का भुगतान नहीं किया है.
It's as simple as that. Below, you can also see the text-to-text translation. So that gives you a bit of a glimpse into what the potential of this is in translating judgments, plaints, and many other legal documents. This has been trained particularly in the text of law, and its potential has several applications, and this is an open AI project. I will now share with you another solution that has been developed by a private company, a startup called Riverus, which helps in all of us improving the way we can research our judgments and legal texts.
It provides insights on income tax cases, making research faster. To access research map, type
So Priya, I think we see still the previous video, and we hear the sound of the new one.
Sorry, I think I'll have to pause and start it again. 1 second.
So your screen still has the language model one, and
okay, I am just do it again. I think I need. Now you can see the new one.
Not yet.
That's strange. Now, can you hear
yes.
it?
Yes,
Yes.
Now we see the new one. Yes, you can play it from the start.
Here we go.
Riverus provides insights on income tax cases, making research faster. To access research map, type incometax.riverus.in. You can look for case laws basis subjects. I'm looking for case laws on depreciation. I press search. What opens up before me is a list of cases where depreciation as a subject has been dealt with. You can filter these by relevance, the date of judgment, and popularity. If I click on popularity, it means that the case which has been most number of times referred in other judgments is top of the list. You can see CIT versus Reliance Utilities with 1979 references is top of the list. You can either get into the case by clicking here, or you can look for the key points which have been discussed in this case by clicking on key points. If you want to look into the case, you click on CIT versus Reliance Utilities, and you can see the judges, the lawyers who have appeared in the case, in fact, the timeline of the case, the section which has been referred. Another utility of Rivera's research map is you can access judge analytics, which could be critical for your preparation. Let's say I'm looking for Justice Pramod Kumar. I type in his name and I press search. What opens in front of me is a list of all judges with the name Pramod Kumar. Let's say if I am looking for Justice Pramod Kumar in ITAT Ahmedabad, I click on his name, and what opens up is a page on the judge, which shows, amongst other things, how many cases has he adjudged in the last 21 years, what was the number of cases disposed in 2021, which are the different fora where he sits, what are the different subjects where he has adjudged, who are the lawyers who regularly appear before him, and a list of cases, the judgments which he has delivered, and so on and so forth. Thank you.
So this is a case of how startups and private sector are using in India, and there are many such enterprises that are using AI, and data to improve how legal research happens. I'd like to now spend a little bit of time on a mission that we as Agami are involved in a very deep way, which is the mission called the Open Nyaya Mission, which aims at improving the transparency, inclusivity, accessible, and openness of data sets for AI applications. I think both Prateek and Rafael were talking earlier about how some of the foundational pieces, the training data sets, actually act as a huge barrier for multiple applications to emerge in the field. And we are trying to approach that as a community-driven initiative to create a public good. We have with us universities, a leading law university, 2 leading engineering institutes, law students, lawyers, and a whole community of innovators who are collaboratively working to address this pain point. The intention is that if we are able to build a training data set, which is required for the machine to get more intelligent and apply different use cases, we can play a significant role, not just making the process easier for many other startups or even the government to be able to find applications, but we will also be significantly reducing the costs of doing so. So the Open Nyaya Mission started last year and has already developed, worked on a training data set of 600 odd judgments in the tax and criminal law space. We involved, on one hand, we identified innovators, what we call justice innovators, who might be interested in this mission, brought them together to learn from each other and interact to understand opportunities. And then most importantly, and what excited us most, is getting students involved in the annotation of these training data sets. As a result of that process, we have this one reference solution, which I will share with you. Prateek, you can see my new screen?
Yes,
this is
indeed.
what the judgment looks like. We are referring to a judgment by Supreme Court of India. What AI can help us do is take this judgment and produce 3 different things. First, it can structure the entire judgment and highlight what part plays what role in the judgment. For example, we know that this yellow highlighted part is preamble. This part is the facts of the matter. This part is the analysis by the court, the precedent relied upon, and the reasoning before the court finally gives an order. The next thing that the AI can do is extract entities from the judgment. For example, what are the courts involved in this, mentioned in this judgment, petitioner, respondent, different statutes and provisions, different organizations involved in this particular case, etc. Having access to this information allows empirical research on large sets of judgment corpus. The third thing that the AI can provide is a very crisp summary for citizens who cannot go through such lengthy documents and understand it. The AI can present a very simple summary of the preamble, of the facts, of the case, the analysis done by the court, and finally the decision. Thank you.
So these three applications, and the last one is just a reference solution so that it helps and it helps in the imagination of multiple solutions that can come over this open training data set. One of the things that we have learned most, Pratik, to your question around what really helps with adoption, is it really comes down to leadership. Right, I think like with any other case, who is deciding, who is implementing, and how do we design as much? I think the ideas and the technology is never really the big barrier. And I think in most of our contexts, we also know that we can garner the resources if needed. But it really just comes down to that. How do we build the imagination of people for what is to happen and the urgency for it in a very, very strong way? I think we see a lot more potential of what is possible in India and solutions around multiple places. One of the things that we have learned in the Indian context is, in contrast to applications that might be relatively more controversial, such as decision-making applications, things that focus more on the administrative dimension, like case scheduling, litigation support, services that you can provide, might find quicker buy-in in contrast to some of the others. In terms of the gaps, the biggest one is I think there would be three big ones we would talk about. The first is the quality of the existing data. Our judgments and contracts vary hugely in terms of format, and our digitization efforts from the court context or the institutions is not strong enough. So getting structured data is extremely hard. The second is the cost of creating training data. The kind of process that we just gave a glimpse to in terms of annotating, it can happen. And I think we need to be really creative and innovative in finding low-cost ways to do this. I think we have found the opportunity in working with students to bring down the cost significantly, but there is opportunity to bring in experts, adopt active learning where possible, and bring down the costs in significant way. And I think a good byproduct of using students in the process, because we run them by MOOCs, I think maybe similar to what you have conducted, with judicial administrators, and that also builds the capacity of young people to engage with the idea and understand what the potential is. And I think I would say the third big gap is around the lack of public actors who can act as almost intermediaries, who can bring in the folks from technology, those from law, and those from government together to be able to develop common vocabulary, common intention, and a common process, right? And I think there is work like this requires such a multidisciplinary approach, and it's not necessary that these communities organize by themselves by design. So I would say those are some of the areas, and I would like to think that if we are all able to come up with clear early applications, focus on some fundamental models, focus on creating some of these core building blocks so that many other solutions can come up from there, curate the right people into the room, foster the trusting relationships between actors, embed openness as design, because that helps build transparency and trust in such solution, and create adequate. I think one of the biggest thing in this is we don't think of the governance models that are required for both their implementation and adoption at scale. I think we have a big opportunity here. And I'd like to just close by saying that we have a Makeathon, an OpenAI Makeathon, where we are going to be encouraging a wider community of actors to develop solutions on top of the training data sets that we are opening up. So if anyone who's listening in has a use case that you think should be prioritized, please let us know. Or if you would like to join it yourself, also please write to us. Thank you.
Thank you so much, Supriya, for the presentation and showing us how some of the solutions work. And I'm already seeing in the chat and in the Q&A, there is some opportunities for collaboration, which is great because we learned from what is going on in Brazil, and there's possibility of cross-pollinating ideas. Even in the Middle East, some of the participants are talking about Arabic language and the language models that you presented. So I think there is opportunity to kind of learn from these exchanges and follow up also later. At this point, I would like to welcome Eric Kariuki from Kenya. Eric is head of the Justice Accelerator of the Hague Institute for Innovation and Law. And Eric would talk about access to justice in the African context. And Eric, the floor is yours.
Thank you, Pratik. I hope everyone can hear me.
Yes, we can hear you, Eric.
Fantastic. Let me just jump in. Today I'm just going to talk about in a broader context how how OpenAI, both in its current state and in its future possibilities, is operating in terms of delivering access to justice in Africa. Of course, I must always caution that as much as I speak for and behalf of Africa, because I'm African and Africa is my business, Africa is not a monolith. It is indeed a very diverse continent made of a myriad of cultures and people, each trying to figure it out as they go along. So Africa, it's one of the youngest continents in terms of its population. It's 1.2 billion people. 70% of those are under 30 years old, and we have around 54 countries. So Africa is inter-country, but it's still a country in terms of a number of the factors that shape our destiny and opportunities. There has been a rapid adoption of technology across all sectors, leading mostly around solutions around fintech and around health tech, and justice sort of is one of those areas that is very nascent and is coming along, and seeing how we can make access to justice much user-friendly, easier to access, and very important. But also one of the key things you must appreciate when we actually touch on Africa is sort of the African voice, in the sense that unlike a few decades ago, most people who live in different countries in Africa are sort of aware of what's going on in each other's countries. We are borrowing a lot of what we see in sort of both the global north and the global south, but also among different countries, and trying to figure out, okay, how can we make this work for us? So with that said, there are key challenges, and how I approach this is looking at first from the access to justice, then looking from a technological point of view, and addressing a bit of the OpenAI question. So when you talk about access to justice, cost still remains one of the biggest prohibitions, in terms of it would averagely cost you a minimum to solve your case between $400 to even going to $1,000 to actually solve a case. So, and this is both in terms of getting a legal expert to handle your case through the formal legal process, but it also could be the additional cost of accessing the nearest court center or courtroom to have that case heard. So the additional cost, and that means access, it's one of the biggest barriers. 2, turnaround time, the efficiency of the formal legal process or system to actually dispense judgments in the most fastest way possible. We have cases that can go on for 30 years. Judgments are being, dispensed 30 years later. So there's always, it has improved over time, but still it's one of the biggest concerns. Trust is a huge factor. Keep in mind, even when you talk about access to justice, most people think it in, when you look at it from a global north perspective, in a very traditional formal structure that, if I have an issue, I go to a courtroom or I get an arbitration and mediation. But the reality on the ground, especially for large chunk of Africa, is that people do not use the formal legal system. In Kenya, we say approximately 60% to 70% use an informal way of solving their justice issues. So only around 15 to 20% actually go through the formal justice system, partly because of issues around cost, but also trust, and also the turnaround time. Ease of use is a big factor in terms of people understanding how do I go, what are the key procedures I need to go through to access certain legal services, but also how to actually navigate sort of the legal formal justice system, and availability. So in terms of how far is I to access legal practitioners? Most of them you find are situated in urban centers, while a large majority of the population still lives in rural places. On the technology side, there has been a growth in terms of adoption of things looking at mobile penetration across different countries in Africa, but infrastructure-wise still remain a huge factor. There is a digital divide. Certain digital services or just getting infrastructure on a digital level are still not that available. Cost is also very prohibitive in terms of adopting and scaling these kinds of tech solutions. And then talent in terms of getting experts and people who can design relevant context-based tech solutions that deliver access to justice. So you have to balance these key two challenges as you're looking at this. So how has AI been adopted? Mostly we have really three formats. So one is government tech. So it's the process we started off with digitizing government services. So we have had a number of governments across the continent, setting up solutions. In Kenya, you have eCitizen. In Rwanda, it's Irembo. So there has been a push towards how can government better and more efficiently provide these services for their citizens. The biggest gap there often tends to be government will push a policy, will adopt the technology, but will not bother educating and onboarding the large chunk of citizens. So you find, yes, there's a system, but we don't know how to use it. And that has been the consistent problem with most of government adoption systems in Africa. They are sort of very top-down, where citizens are not engaged in the conceptualization, design, and actual execution and rollout of such technology. Law practice management systems have been common for legal practitioners in terms of improving analysis, case management, as well as billing. So law firms are actually becoming more and more open to adopt technology into their institutions to make their work much easier. Most of these are driven mostly from a point of how to improve sort of caseload management, but also in terms of billing. And then one of the biggest areas that I love to work in, and I'm working, is sort of private solutions. So these are startups and innovators who are developing amazing solutions towards making certain, most of this legal access and legal services more available. We have Rainbow, who's based in South Africa. So they provide, it's a chat box that provides domestic violence survivors to access key information around how they can navigate sort of the legal system and what help and support they can get. Sheria Kiganjani is in Tanzania. It tries to basically provide a large population of Tanzanians, both in remote rural areas, with legal advice in a language they understand, which is Kiswahili, which is the national language, but the law is predominantly in English. We have DOI law, which provides legal documents that in an understandable way in Nigeria, so people can actually self-service in terms of drafting their own sort of legal documents. And we have Barefoot, which is based in Uganda, that's supporting ordinary citizens access legal information and legal services. So there is this mishmash of solutions currently operating in terms of sort of also filling the gap in terms of access to justice using tech. Where do we see the future? Well, one of the key things is looking at how can one bolster and embolden sort of the institutional justice systems at a court level, whether in terms of predictive case management and research. Unfortunately, in most of our courtrooms, judges still literally hand a pen and paper are writing the court notes as they're listening to both the applicants before them. And so how do we develop, case systems that can pull on judgments, look at precedents, and ensure that they can do more efficient and more up-to-date research. Language translation and transcription. Language, we have over 2,000 indigenous languages in Africa. Then we have your typical different national languages, but predominantly you find there is an area of exclusion in terms of how language, in terms of access to justice, becomes a barrier because people do not understand, or the legal language itself is very legalese. It has very jargon, it excludes. Unless you have somebody who is conversant with it, they are not able. So looking at how do we actually tap into that to make one language that is used when we're administering justice is user-friendly, is understandable, and can cater to different needs and people wherever they are. And then in terms of evidence management and recording, how do we use AI to capture relevant evidence, whether it's in areas of
hi, Eric, I think
war zones where people need to, or in terms, sorry,
we just lost you for a second, but I would request you to conclude in a minute or so, if that's okay.
Okay, I'll wrap up. So what have been the key drivers for adoption is mostly that it's the need for people, the need for people centered in user-friendly justice solutions. So people want to access justice, they feel there is that need, but they need it in a way that meets their needs wherever they are. There's a need for efficiency and effectiveness, at least in the institutional level. How can we reduce the caseload, make it more, improve the turnaround times, ensure there's a level of a better management of outcomes. But then there's also an issue a lot, and we see it in Kenya in terms of privacy and data protection. How is more citizens and more people are more concerned is who has our data? How is our data being used? We have had cases, in Kenya where the government wanted to introduce the Huduma number, which is a sort of integrated ID system, and there were concerns around how data is used. But also, large thing is the age of misinformation and disinformation. In terms of, we've seen it in Ethiopia where there was a lot of Twitter bots that were, spreading a lot of misinformation, and how can, a system sort of manage and deal with them in the most efficient and effective way, because it's sort of where we live at the moment. So my key takeaways when you're looking at OpenAI and how we use it here, it has to be people-centered in terms of the whole process from design to adoption. How are we engaging the end user and not having top-down solutions while managing their expectations and risks? There has to be a level of inclusion. We have talked about biased data sets and who drives the process and whose voice gets heard. How do we include everyone? But then there's also a conversation about strengthening the policy space. How do we get the right stakeholders, both in the technology space, in the justice space, to come together and actually formulate robust policies that are effective and deliver better outcomes. And I'm done. Thank you.
Thanks, Eric. Thanks for keeping the time. So I think there are a lot of common challenges, but first I'll try to, in the 8 minutes or so that we have, throw two questions at you, which we have coming from the chat. First question is for both the Indian and the Brazilian search models. Do they enable gender-based analysis to produce dashboards or reports, for example, on how many decisions issued in a given year are issued by male judges versus female judges, or what the representation of female lawyers is over a series of decisions? And this question comes from Marcela Dai. So pardon me if I'm pronouncing your name incorrectly. Rafael, Supriya, Eric, anyone who wants to take the question, short answers, and then we move to the next question. Supriya, you want to go first?
Yeah, I can go quickly. So it really depends, because right now we don't have these models offered by the government, but in some of these private models, yes, they can be, but not because but those are limited. We must understand that they don't represent all of the judgments in the country. They're usually defined by domain, like relating to tax cases or another subset domain. So to the extent that some of these private models have developed, yes, they can, but those have their limitations.
Thank you for that. Rafael or Eric, do you want to weigh in? Or I saw that Rafael has already responded in the Q&A to that question. So perhaps we move to the other one, which comes up quite often, which is around data protection. So we're talking about training data and analyzing a lot of the data from the justice sector. What about data protection? I think this is an important one. I don't know if any one of you wants to go first. Eric,
yeah.
Okay, Supriya, you want to go?
I mean,
go ahead.
I can quickly say we don't have a formal policy in India as a country for data protection, and then particularly with the judiciary and law, you know, in the field of the judiciary yet. Both these are being formulated and have been very alive subjects. There are different approaches to how people are considering them, but because today none of these things are actually open, like I mentioned, because the data is not yet open from the government, hasn't yet become an urgent thing to sort of conclude and close, but those are policies in the process of formulation, and I'm happy to speak to whoever to say how they are being considered, like what are the frameworks being applied to see how we should approach them. I've detailed a bit more in the chat board.
Thanks, Supriya. Eric, yes, please go ahead.
So for us, for example, in Kenya, we have a Data Protection Act that came in 2019. It was driven by the very fact that the government was adopting a technology, this integrated ID system with no framework for data protection. And sort of through the court system, it was, we cannot go ahead and adopt this technology if there is no framework for data protection. So the framework, the act has been developed. Its effectiveness, its operationalization in terms of actually being used is still an ongoing conversation, and there are still limitations in regards to the act. And this is an area that is constantly being developed. And also looking at data protection on a wider spin in terms of how it affects also those groups that are often not sort of, they're marginalized from the get-go, such as refugees and how we use, the information. Yeah.
And there, Rafael, do you want to add in on what kind of data protection features, the massive amount of data that you're working in Brazilian system, how are you addressing that?
So the first user of data that we're collecting is the user, the system user. So it's the one that has already access to the data is the first one that we're thinking when we are hosting the data in a central system, in a central infrastructure. But despite of that, we are enforcing personal protection data in all courts. We have in around most of them, we have the personal data authority that will be able to respond to requests and take measures to ensure that no personal data is unduly used. And in the systems that we're collecting data from all those lawsuits, it's replicating the same levels of secrecy and confidentiality from the lawsuits. So we do it at the lawsuit level, but also at the document level. And we only give access to the person who should have access to it. So it's of main concern, but in a way that's not hindering the possibility of having access to all that data, because I think that that's a central issue. We can't think of personal data protection as something that should hinder the getting open data and thorough access and an integration of those systems, because when we have the information in the system, we can effectively control who's accessing it. So it's kind of counterintuitive. It's the opposite of what you would expect. It's much better to have all the data ready and available somewhere, and you can see effectively who's accessing it and what use is made of it, than not getting all the data together and readily available.
There is always a debate between utility and data protection, and what levels of control and anonymization and kind of administrative control. I see that Supriya has also put in a remark in the chat of different access levels and so on. I think we have no more time, but I am briefly inclined because there is a question around corruption. And I think it's an interesting intersection. So Rafael, that's addressed to you. So how can some of the data that is being generated, and there are probably ways to analyze it, which can also help us in fighting corruption, but you have 30 seconds.
Great.
The interpreter will not be happy otherwise. So please.
I think it's in line with what we are talking. So it's when you get transparency and you can see effectively what's happening, it's you kind of disincentivize having corruption. So the idea with having big data readily available in AI, it's going to be a lot easier to comply, to get the same decisions every single time, and see whenever someone is unduly not following the decisions that they had before, or applying a different system to a specific group of people or to a specific person or lawyer, that will be readily available and come up to the knowledge of everyone when you have that data available, and you have systems that are enforcing them and suggesting the best practices and what you should do. So I think the overall tendency is that we're going to see a lot of improvement, and mainly because it's a lot easier to criticize an algorithm than to criticize someone. So when you have a bad AI system that is implementing a corrupt decision, it's easier to say that system is not working, that's a bad system, and you go there and change and make another version. When it's someone, a person, it's in a different level. They'll have a tendency to defend themselves, that that's not my intention, you did not understand me. So it's kind of difficult to have a second version of someone, but with AI, it's quite easy, and I think we will make things better and faster and less corrupt, as the question was asking.
I just want to add a small comment there, that even if an AI system is used, I think ultimate responsibility should lie with the designers and developers and the organizations deploying AI system. It should not be the case that it's without accountability and we say, oh, there's an algorithm, because there are people who are designing it. So we need to keep that human-centered approach there. I will thank you, everyone. I think in parting thoughts, some of the key takeaways that I could quickly jot down were solutions that help in administration of justice have greater buy-in. And we've seen language and translation is an important issue for access to justice. And I want to mention that the Open for Good Alliance is working on creating data sets in low resource African languages as well. So please feel free to check the website and the Mozilla Common Voice project. An issue of transparency and openness came up several times, and it's key to building trust in the use of these tools. Leadership and community play an important role in creating a buy-in, and we need to think about implementation and governance mechanisms, and ideally these should be multi-stakeholder driven and inclusive. I would be remiss to say if we don't talk about the digital divide. There are 3.6 billion people still offline, which is 53.6% of the global population. So we need to be conscious of that, and only 28.2% of the people have internet use in least developed countries. So we need to be very conscious while we're talking about AI. Gaps remain in training data. And finally, education and capacity building, both for users of these systems, but also for people who go to court systems to be able to access these services and make digital transformation effective, are extremely important. We do have a short survey put in the chat. I hope some of you have answered, and we look forward to engaging with you. And I hope some of the conversation has sparked some new ideas for collaborations between different parts of the world. That's one of the main objectives of UNESCO, to strengthen international cooperation and awareness. And I thank you all for joining us today, and we'll keep you updated on upcoming sessions on AI and the rule of law from UNESCO. Thank you so much. Bye-bye.
Bye-bye. Thank you so much, Prateek.
Bye, everyone. Pleasure talking.
Thank you. Bye-bye.